But to kickstart, we would look at the key terminology, which I think is important when you're talking of conventions and all the international legal framework. And for example, I mean, in advocacy work, when one is doing advocacy, one needs to know whether a country or government has either accepted and approved the international, the convention or the treaty, or is it just accession, ratification? All those terminologies, they need to be understood. And maybe to kind of explain, for example, I mean, what do we mean by acceptance and approval? According to the Vienna Convention on the law of treaties, it's whereby states establish an international plane or consent to be bound by a treaty. And
Rampe, I'm sorry to interrupt you. I forgot to say, if you could just speak slowly and give a little gap after each sentence for the interpreter.
Oh, yeah. Oh, sorry. Yeah. I'd forgotten about the interpretation. Yes. So when we talk of acceptance and approval of either a convention, a protocol, or a treaty, the Vienna Convention on the law of treaties, the 1969 Vienna Convention, basically explains it as a situation whereby a state has establishes on an international plane its consent to be bound by that convention or by that treaty. So, and accession, ratification, and treaty, they are more or less explained as more or less the same, if one may put it that way. And then when we come to the concept of migration, I think it's sometimes these terminologies are used interchangeably, and it's also important to understand whether one is talking of an inclusivist or residualist definition of migrant. And as you can see on the screen there, I think this explains it very well, where you can see that when refugees, when you talk of migrants, it can mean any person who is moving or has moved across international border, or even within the borders of his or her country. Whereas a refugee, it would be somebody who has moved outside the country and specifically fleeing persecution or war. So that's a kind of overall global explanation or understanding. And I thought maybe it would also be important for us to look at the different categories, because when doing advocacy, one has to understand who are we advocating for, or who are we, or what are we talking about. So we have the people that have been displaced or that have decided to voluntarily move from one place to the other. And so advocacy means that understanding the technical terminology and the categories thereof, it's very important for an effective advocacy strategy, as it were. So I've put in the link there where you can see, I mean, I've just put few. There are many more. If you click on that link, I think we will share with the people. If you click on that link, and you will see there are many other terms that are pertaining to migration that one would need to understand in this work, in this advocacy work for migrants and refugees. So I thought before we start, it would be important also to understand, I mean, being a Catholic, to understand why we do this work. Obviously, the values, the scriptural or gospel values underlying here, but also the social teaching of the church is also important. And as you can see there, those key principles of the Catholic social teaching of the church. And I think it's also important to understand that, that Catholic social teaching is essential and central to element of our faith. It is an expression of the relationship between fides and ratio. It is also, it's not necessarily socio-economic, but it's theological, meaning moral and ethical. And I think this is one of the points that was highlighted by Pope Benedict in his last address to the UN General Assembly in 2008, just before he retired as Pope. So the social teaching, it encompasses all ideas, teachings, and theories of social life. And it is basically literature written by popes, bishops, and church leaders as a response to countless political, economic, and social injustices. And I've put that quote there from Ban Ki-moon because I think one of the challenges when we talk of migration today, it's that lack of solidarity, which is one of the key principles of the social teaching of the church. And Ban Ki-moon, I think it was in, just before his mandate finished, he said, you know, we are facing the biggest refugee displacement crisis of our time. But above all, it is not just a crisis of numbers, and it is also a crisis of solidarity, which is true because when you look at the international legal framework and the domestic legal framework, which James will be touching on, you realize that there is more and more movement away from what used to be called burden sharing to actually maybe criminalization of migration and all that stuff. So solidarity is slowly becoming a thing of the past when it comes to migration and dealing with migration and hospitality towards migrants and refugees. So as we saw in the video, Pope Francis, he mentions the 4 verbs, and the 4 verbs, which I think they are important for us, and he underlines the fact that the 4 verbs, they sum up the response to the challenges that are upon us, to the political community, the civil society, and the church. So all of us, if you look at the 4 verbs, this, as Pope Francis puts it, this is how, and this is how I try to look at this legal framework using those 4 verbs to try and understand and see how we can do advocacy by using those 4 verbs of Pope Francis. So when we look at the work to welcome, enhancing safe and legal channels for migration, for migrants, we look at, you have, by the way, you would see some of the instruments, I repeat them, some are there, some are not there. This is just one of few examples just few examples that I thought would be most relevant in these categories, and there are many more that could still be applied in this. So they are not; it's not exclusive, if I may put it that way. So when you look at welcoming, like for example, the Universal Declaration of Human Rights, you look at Article 28. It talks of everyone is being entitled to a social and international order in which the right and the freedoms set forth in the Universal Declaration for Human Rights can be fully realized. So, and I think we have all these, the Geneva Convention, the Protocol 1967 Protocol, the OAU Convention, and the Global Compact. And when you look at the conventions, the Geneva Convention and the OAU Convention, they give a definition of, for example, a refugee, but sometimes it's technical and very limited. But I mean, over and above the definition of a refugee, for example, I would like to look at the OAU definition, which is much broader than the Geneva Convention definition, which kind of, opens up this welcoming element of migration. And as you may know, that according to the classical definition, a refugee is a person who, owing to fear of persecution, or has been forced to leave their place of dwelling. But when you look at the OAU definition, it also goes further to include external aggression, occupation, and foreign domination, or events seriously disturbing public order in either part or whole of his or her country of origin and nationality. So it kind of opens up the welcoming and the constituency of people to be welcomed in when we talk of refugees and asylum. And Article 2, also touching on asylum, it talks of member states of the OAU to use their best endeavors and consistent with their respective legislation to receive refugees and to secure the settlement of those refugees who, for well-founded reason, are unable or unwilling to return to their country or of origin or nationality. So that spirit of welcoming, it comes out in the OAU Convention more than in the Geneva Convention, if I may put it that way. To protect. Pope Francis, when he talks of to protect, he talks of, it's about ensuring migrants and refugees' rights and dignity. So you look at those instruments that are included under this category. You can see the list is not exhaustive, but there are so many of them that we can look at, and one can familiarize oneself with. But I think I would like to touch on specifically on the Convention of the Right of a Child. For example, you look at Article 11 of the Convention of a Child, which talks of states parties to take measures to combat illicit transfer and non-return of children abroad, which nowadays we have a problem of trafficking and all that. And the state parties shall promote the conclusion of bilateral agreements or collaboration, basically, to make sure that everything is done in the best interest of a child, irrespective of the roots of a child or where the parents or nationality of the parents. So, and then we look at also the Universal Declaration of Human Rights of 1948, Article 15. It talks of the right to nationality for everyone. We know nowadays we are faced with the problem of statelessness, and many people, and this right, it's actually at the moment, I would say, one of the most, well, not one of the most, but quite violated in many ways nowadays. And we'll see that when James talks about statelessness and all that. And then we have Article 14 in the same Convention of Universal Declaration of Human Rights, which talks of the right to seek and to enjoy in other countries asylum from persecution. So anyone has a right to seek asylum, and this right, we know, with so much hostility and many governments and states not wanting to take responsibility, it has become a big challenge. I think that's one of the challenges that we are facing nowadays. And then when we look at statelessness, we look at, particularly in Africa, we have the 1954 Convention, and which is the UN Convention, and the 1961 Convention. But specifically here in Africa, in West Africa, we have what we call the Abidjan Declaration, and James will touch on that as well. But what is interesting about the Abidjan Declaration is that it calls on all ECOWAS member states to reform discriminatory nationality laws or the gaps in their legislation, and it encourages everybody, or it basically advocates for the entitlement or the nationality of everybody. And the declaration requires that all the ECOWAS member states to prepare a plan of action to end statelessness. So I think this is a powerful kind of regional instrument, which I think the West African states, the majority of them, they have actually responded positively towards it. And this declaration, it seeks to, or it encourages the member states to make a commitment to the conventions, the 1954 Convention on the Status of Statelessness and the 1961 Convention on the Reduction of Statelessness. So member states should commit themselves to that according to this Abidjan Declaration. So currently we have 12 of the 15 states are signatories in this convention in the ECOWAS community. But the commitment that was made by the ECOWAS in the Abidjan Declaration are now being used to further and strengthen the resolve to eradicate statelessness more widely in Africa. So, for example, Article 5 of that declaration calls on the African Union to prepare and adopt a protocol to the African Charter on Human and People's Rights on the right to nationality. So there is I would say that is a kind of a progressive move towards protecting migrants and refugees, and in this endeavor to end statelessness. And of course, you have also the United Nations Convention under this category of protection. One can look at the United Nations Convention against transnational organized crime, which was adopted in 2000 and entered in, it was enforced since 2004. And it talks of the return of smuggled migrants, and it encourages states to facilitate and to accept the return of smuggled people or smuggled persons. And it also discourages the criminalization of those smuggled people, but also says that each state party, Article 6, each state party shall adopt legislation or measures that may be necessary to establish as criminal offense when the smuggling of people and all that. And then under protection again, I think I would like to, coming back to Africa, look at the Kampala Convention. Article 2 of the Kampala Convention, which looks at the objectives of the convention, which is to promote and strengthen regional and national measures to prevent and mitigate or prohibit and eliminate the root causes of internal displacement. And in most cases, it could be the same root causes that forces people to leave their countries. But it also encourages the endeavor or work towards durable solutions for IDPs, as it were. And then we also have the human trafficking, Article 3 on the United Nations Protocol, the 2000 protocol, which encourages to suppress and punish trafficking in persons. And so member states are actually encouraged to make sure that those who recruit or are involved in transportation or transfer or harboring or receiving persons who have been moved by force or coercion and deception and for reasons of forced prostitution, as we know, forced labor, or even slavery, or even nowadays we hear of organ harvesting. So states are encouraged to punish those who are involved in such activities. So this is one form of protecting migrants and refugees or those who are forcibly displaced. Sorry, I need to go to promote. So when you look at to promote, Pope Francis talking of to promote, he talks of advancing migrants and refugees' integral development. And I think when you look at the preamble of the Universal Declaration of Human Rights, firstly, it talks of the dignity of the human person. And I think it's important for us to realize that, as it is stipulated in the preamble, that that dignity needs to be promoted and protected. And through that, we look at the convention, for example, the convention of, or the African Charter on the Rights and Welfare of the Child. It does a bit and provides in Article 6 that every child has the right to a name at birth. Every child shall be registered immediately after birth. Every child has the right to acquire nationality. And we know that in many instances, many migrants, stateless children, unaccompanied, there's a problem of documentation. And without birth registration, that leads to lack of documentation. That leads to lack of access to all sorts of facilities in domestic legislation, in host countries. And that is a major problem. And that dignity, the human dignity that is alluded to in the preamble of the Universal Declaration of Human Rights is violated. So it's quite important that we look into those things. The Geneva Convention and the OAU Convention, of course, for example, OAU Convention Article 6, it talks of refugees being accorded travel documents. We have in some instances, and it has happened, especially here in South Africa, where documentation, sometimes people being denied documentation, including travel documentation, where they sometimes lose opportunities for their development. And so things like travel documents. I remember there was one refugee who was refused a passport, having received an invitation to go and participate in a conference for his studies and all that. So things like that. Sometimes you find migrants and refugees being denied opportunities because of the lack of documentations and documentation, especially travel documents. So African governments have increasingly acknowledged that migration as a strategic pillar in their national development plans. And as of, I think, for example, in the ECOWAS region, as of 2015, all but 2 ECOWAS member states, Benin and Guinea, had cited migration in their national development strategies. And I think it's something that we need to promote and encourage in the continent at large. To integrate. When you look at the convention, for example, the convention of it talks of the child being registered immediately at birth. And like I said earlier on, if that is not done, many become stateless. They are not afforded opportunities to study, for example, education and all that. And they cannot fully participate. Firstly, they cannot enjoy integral development. They cannot participate in the activities of their community. So they are denied integration, as it were. And statelessness is one of those challenges that we see people being literally denied the opportunity to fully integrate into the communities into the host communities and become members of the human family where they find themselves or where they are. So integration, and we know all again, it's also one of the 3 durable solutions according to UNHCR, or preferred durable solutions. So it's important that in our advocacy work, we look at those instruments that promote integration of refugees and migrants into communities, because that plays a major role in helping them to feel at home and to feel safe, to be protected. But also, it's also an opportunity for the host community to gain, because it's all, there's cultural enrichment, mutual cultural enrichment, if it is encouraged and allowed to flourish, integration in the host community. In conclusion, I think if you look at Article 15 of the Vienna Convention on the law of treaties, it stipulates that the consent of states, of a state to be bound by a treaty is expressed by accession when the treaty provides that such a consent be expressed by that state by means of accession. And so the challenge, I think, that we are faced with is that you have states either ratifying or accepting the international conventions and agreements. Some, they do it with, how do you say, with reservations, or you find that there are certain reservations. For example, if you look at the Geneva Convention, in principle, some reservations are permitted at the time of ratification or accession, and in accordance with Article 42 of the Convention. However, you have a situation whereby reservations may not be made to several fundamental provisions, like, for example, of Article 1 of the Geneva Convention, which deals with the definition of a refugee, and Article 33, which deals with the non-refoulement, and Article 3, which deals with non-discrimination. So those, although states can ratify a convention with some reservation, those are kind of non-negotiable. And it's also important to realize that reservations can also be withdrawn. It's possible. And lastly, I think what is also encouraging is that to see the Global Compact for Migration is framed in such a way that if states participate positively and collaborate positively, it can actually come up with a solution in the legal arena, in the international arena, towards protecting and supporting migrants and refugees. So things like the Global Compact would need to be encouraged. But unfortunately, the Global Compact, it's not binding. It's a non-binding document or agreement. So those are some of the challenges, maybe when you look at the international front of legal international refugee law. So some are binding, some are non-binding. And then I would say, in conclusion, the 20 action points that we find in the Global Compact, and together with the international regime, I think they provide us with instruments to be able to respond positively to the situation of migrants and refugees, and tools to implement advocacy activities wherever we find ourselves. And then I have just put in a few sites where you can find all these important conventions relating to migration and refugees. With those few words, thank you so much. I went a little bit overboard. Many thanks.
Thanks, Rampe. Well, you are a priest, and we know that priests, when they preach, they often just take a few extra minutes. So no problem. James, do you want to carry on at this stage? I think we'll just go straight into your presentation. I just remind you that there's a lot of technical terminology in names of conventions, etc., in what you guys are talking about, and the interpreter will need some time to breathe, as she interprets all of those things. So try to keep it fairly slow in your delivery.
All right, I'll try to do so. Great. Can everybody see the presentation?
Yeah.
Yes.
Okay. All right. So we're still looking at the legal aspects of advocacy for migrants. And my task is to take it from the international instruments level down to the domestic context. And so, yeah, let's go ahead. So we're going to be looking at the sources of law and development of the law, the tenuous rights and status of migrants, some important questions concerning domestic law, domestic legal framework, constitutional legal provisions of host countries, principles through legislation and case law, including non-refoulement, non-penalization, statelessness, and trafficking also to a small extent. Considering certain aspects of migration and refugee law with country examples. And throughout we'll be looking at some kind of maybe suggestions or ideas of migration advocacy and maybe some of the cases. All right, so in terms of sources of law, there are a number of sources which include the Constitution, legislation, statutes, common law in terms of common law jurisdictions, customary law, international law, and then case law developing the law. I'm just going to pass this quickly because a lot of that is things that you're very well aware of. I'm now going on to the tenuous rights and status of migrants. So we know about migrants on boats that flee from North African countries like Libya. The boats often are over capacity. Boats are returned. Others sink. Migrants drowned. Then we have a category of migrants who are smuggled with the assistance of smugglers, and particularly with COVID-19, the cost of smuggling has been escalated, and there's some extreme risks that arise with smuggling, including health risks with COVID-19. Smuggling is distinct and separate from human trafficking in a number of respects, and maybe if anybody's interested, I can go into the detail. But yeah, I thought I would just mention that. Sorry. Then refugees is another community fleeing from war or persecution, sometimes with little to no belongings. In some cases, officials, soldiers, police, intelligence services who are charged to protect are sometimes the very perpetrators of attacks, rape, assault, incarceration, or murder. We see, for instance, in parts of Eastern DRC, there have been a lot of instances where there has been the state actors, state soldiers have been found complicit. And then similarly, we see with the situation with the government youth movement in Burundi. So yeah, there are definitely instances where the state is actually involved in perpetrating refugee-causing situations. Many refugees and IDPs, internally displaced persons, as a result of these acts by police or soldiers, by the state, often distrust the authorities and are hesitant to approach the authorities. And they'd also be hesitant when crossing borders to go through official entry points where they fear that they may be subject to similar abuse or return to their country, to the violent persecutorial environment that they actually fled from. I did mention already some examples, but I mean, we see this with Somalia, particularly Mogadishu and southern Somalia, where the state is not able to adequately protect. We also see the situation in Cameroon, particularly in Western Cameroon, where there's tension between the Anglophone population and the majority Francophone populace. We've seen in Nigeria religious persecution with the actions of Boko Haram. Recently, we've seen since sort of 2017, 18, 19, and to date, challenges in northern Mozambique. There are a lot of examples, unfortunately, of refugee-producing situations. There are mixed migration flows, so many cross borders through legal channels or not, in the process of being trafficked. In terms of human trafficking, there are various elements to human trafficking. There needs to be an act, there needs to be the means, and there's the purpose of exploitation. There's a lot I can also speak to about human trafficking, if there are any questions about that. Can you still hear me? Is everything fine?
Yes, everything is fine.
Okay, great. Okay, other people on the move have left for economic reasons, finding that there's little to no job availability or prospect of further education, and migrate seeking better opportunities. We find others may have left because their homes have been washed away by flooding, and maybe the last of their livestock has died out, or there's a drought and the absence of crop yields result in starvation. Climate change and natural disasters bring about migration in some instances, like these. In another instance, a person may not be or may no longer be recognized as a national of a country and may leave seeking some form of recognition in another state. There are examples. I haven't put it on my slides, but with that one I mentioned about seeking job availability or prospect of further education. In South Africa, we have had various dispensations which have been provided to allow for low-skilled sort of economic migrants. For example, you have the Zimbabwean dispensation permits, the Lesotho dispensation permit, well, special permits, the Angolan special permits, and some of them have been renewed as well. So that's just an example of that. Okay, some important questions arise when you're looking at the domestic context, your legal provisions in the host country. And I'd like to encourage the participants to do this, to look at your local framework domestically. How are migrants received? How are they welcomed, protected, promoted, and integrated? Carrying on from what Father Rampe was speaking about just now, the Pope's four verbs. What rights, protections, and safeguards exist? To be effective with advocacy on behalf of migrants, and I can't really emphasize this enough, it's really important for us to know the law that applies to migrants, to be aware of the organizations and practitioners that assist in ensuring that the laws are upheld and rights are respected, and then to seek out the avenues and mechanisms for rights realization. Yes, unfortunately, migrant communities are particularly marginalized, and it's crucial that we have effective advocacy efforts. In instances where migrants are not protected or promoted, it is essential that we advocate for migrants' equal protection before the law. Okay, some more questions. Does your country have refugee or asylum legislation? Does it have a Refugees Act or an Asylum Act? Is there an Immigration Act which speaks to migrants' rights? Is there counter human trafficking legislation? What citizenship or nationality legislation is there? And this is often tied to statelessness preventing legislation, because statelessness is the absence of citizenship or nationality of a country. So if there's legislation that allows for individuals to become registered as citizens, then that's crucial. Tied to that as well is birth registration legislation. And one would want to look at, is the legislation applicable to migrants in the country as well and to their children? In the South African context, for example, there are huge challenges with the implementation of a Birth and Death Registration Act. In other countries, like for example Zambia, there's huge issues with the rate of birth registration, where only 20% of the populace's births are registered. Birth registration is very important from a migrant perspective, including whether it be the statelessness situation, whether it be any other migrant situation. The vulnerability is increased if you don't have birth registration. Then another question, does your country have a constitution that protects the rights of migrants? Is there legislation or policy providing for economic migrants, migrant workers, migrants to study? And those special permits I mentioned earlier was an example of interventions in that regard. Legislation or case law protecting the right to equality, dignity, life, not to be subject to torture, cruel, inhumane, and degrading treatment? Is there a robust judicial system in which migrants and advocacy, migrant assisting organizations may approach the courts to protect and promote the rights of migrants? Is there legislation safeguarding fair trial rights, accessing legal representation for migrants? If so, are these laws provided for the rights of migrants? Are they properly implemented? And if not, is the country a party to international treaties and conventions that Father Rampe was just speaking about just now? And if they are party to them, then we should advocate and can advocate for the application and domestication of those. I've just flagged here undertakings, because when it comes to certain of the conventions, for example, the statelessness conventions, we see a lot of countries that undertake to sign and ratify the conventions, but after years of having undertaken to do so, like in South Africa since 2011, undertaking to sign the statelessness conventions, we still have not. South Africa still has not signed, and so it's important to have advocacy for that. In whatever position the legal framework of the country is in respect to the laws safeguarding migrants' rights, there's always an avenue and opportunity for advocacy to welcome, promote, protect, and integrate migrants. All right. So constitutions, most of if not all of the countries participating have constitutions. in terms of the South African Constitution, and there are similar provisions in other constitutions, the South African Constitution is supreme law. Any inconsistency with it is invalid. The Bill of Rights grants the right to equality, dignity, education, safety and security, and access to court to everyone, not just to, including to migrants and refugees. And the Bill of Rights should also promote values and international law, and give effect to international law. If we look at the Zimbabwean constitution, you see a similar supremacy of the constitution. We see in terms of section 36.3, a special provision that guards against statelessness. So a child found in Zimbabwe who is or appears to be less than 15 years of age, whose nationality and parents are not known, is presumed to be a Zimbabwean citizen by birth. Because otherwise the person would be at serious risk of not having any nationality or any citizenship. The right to personal liberty, it says every person, rights of arrested and detained persons, any person, equality and non-discrimination. All of these are talking about all persons, every person, so they include migrants. And particularly in countries where there's no proper migrant protecting legislation, or where the legislation isn't being properly implemented, it's really crucial that we look to our constitutions. Just coming back to section 59.3, it says, every person has the right to be treated, not to be treated in an unfairly discriminatory manner on such grounds as nationality, race, color, tribe. And so in particular, they actually highlight specifically nationality as a basis on which one cannot be discriminated against. All right, and then in terms of legislation and statutes, I've just given some examples. So if we look at the South African context, one of the key point I'm wanting to make here is that there are pieces of legislation that are very specific and clearly relate to migrants, but there are other pieces of legislation that have a big impact on migrants that you wouldn't think of initially at the outset. For example, the provisions of the Criminal Procedure Act, where migrants are arrested, you have the right to free legal representation for all criminal matters. You have to appear before the court within 48 hours. You have access to bail in terms of section 60. It's interesting and a little bit was frustrating to note that in South Africa, up until 2017, the same safeguards of being brought before court within 48 hours were not afforded to or not given to migrants who are arrested for deportation, because arrest for deportation was treated as a administrative matter rather than a criminal matter. And so people would languish in prisons for long duration without being brought before the court while they awaited deportation. Unfortunately, there was a case in 2017, the Lawyers for Human Rights versus the Minister of Home Affairs case, in which the court stated, specifically the Constitutional Court stated, that migrants who are under arrest must be brought before court within 48 hours of their arrest and detention. We have the Refugees Act, 130 of 1998, the Consumer Protection Act. In terms of the Refugees Act, there's a number of things that I've highlighted there: the principle of non-refoulement, the definition, the process, non-penalization. But I'm going to come back to that later on in the presentation. And then, as I said, there's the Consumer Protection Act. There's the Schools Act, access for migrants and refugees to schooling. The Prevention of Illegal Eviction and Unlawful Occupation of Land Act. In terms of our advocacy, it's very important, as I said, that we know the law, but we also that we're sharing the information with migrant communities. Because in practice, we find, for example, in South Africa, a lot of refugees, asylum seekers, migrants are have their children denied access to schools. Their children aren't able to access exemptions where they can't afford school fees. There are unlawful evictions taking place. There's unfair labor practices, unfair dismissals. And all of these things are protected in terms of South African law. The right to education in terms of the Constitution and in terms of the Schools Act, the right not to be unlawfully evicted in terms of the PI Act, the Prevention of Illegal Eviction Act. And labor rights are extensively protected in terms of the Labor Relations Act, as well as the Basic Conditions of Employment Act, that's BCEA. There's the Immigration Act that also governs certain migrants. And then there's the Citizenship Act and the Birth and Death Registration Act, which are particularly important from the statelessness perspective. So those are just some examples of legislation. You would want to look at the legislation in your domestic context. Okay. Just the definition of a refugee. I'm not going to go over that again because it was covered in the previous presentation, but just to mention that we see the first definition is a domestication of the 1951 convention definition, and the second definition is a domestication of the extended definition that Father Rampe was talking about, that in terms of the 1969 OAU convention. All right, that's just a little bit more about the two definitions. I'm happy to speak to more to who is a refugee and what legislation provides in terms of refugees, should anybody have any questions on that. In terms of the burden of proof and the standard of proof, so at least in common law jurisdictions, the burden is on the applicant to establish their claim. And that's also the case from the UNHCR perspective, but the whole process is inquisitorial. So it means that the decision maker who just determine whether somebody is a refugee may also adduce evidence and shares the burden. The other thing that is interesting when it comes to refugees in particular is because of the seriousness of the situation for that refugees find themselves in, and the ramifications or the results if they were to return are so serious. There's a much lower threshold than is required at criminal law or even at civil law levels. It's not balance of probabilities or beyond reasonable doubt. All one has to establish is the reasonable likelihood or the reasonable possibility of persecution or risk of harm. And if there is even the reasonable likelihood or the reasonable possibility, then that is enough to get refugee protection. Okay, so Father Rampe has touched on the principle of non-refoulement. This is an example of the principle of non-refoulement implemented within the domestic context. So non-refoulement is a French word because it's supposed to be broader and more encompassing than non-return or don't return, because it also includes those who are trying to enter into a country, those being extradited, those being removed or expelled. All of those fall within categories that are protected in terms of this principle. Okay, and so there's an example. If you fall within the definition of a refugee, then you are protected from being returned. And that's the bedrock. That's the most important provision in terms of international law and domestic law with respect to refugees, that people cannot be returned to a place where their life, liberty, fundamental human rights would be at risk. Tied to that is another important provision, and it connects to what I spoke about earlier, where sometimes people leave with next to no belongings and they have a distrust for the state. If you had to use proper official legal channels to enter into a country in order to get refugee status, then that would exclude a lot of people who have genuine refugee claims, and it also might result in people being returned in countries that they would otherwise transit. So in terms of the 1951 convention, which is domesticated in terms of South African law here, notwithstanding any law to the contrary, no proceedings may be instituted or continued against any person in respect of his unlawful entry into or presence within the Republic, if such person has applied for asylum in terms of Section 1, or such person has been granted asylum. And there's a number of cases that were addressing that, and I can speak to some of those cases if there are any questions on that. I just want to also skip forward a little bit to this slide. If we look at the Zambian context, in Zambia, migrants in general are provided for in terms of the Immigration and Deportation Act of 2010, which, among other categories, allows for the arrest for illegal entry or illegal presence. But we see the same kind of provision that was implemented in South African law, carrying on from the 1951 convention, the non-penalization clause, is also reflected in Zambia's Refugees Act of 2017. And there, in that act, in section 46, it says, despite the provisions of Part 5 of the Immigration and Deportation Act of 2020, proceedings for unlawful entry or presence in Zambia shall not be instituted or continued against any person or a dependent of that person who enters or is present in Zambia without lawful authority. And then it goes on to talk about without delay approaches and becomes recognized in accordance with the Act. So it's just an important point to mention there, that one of the things that goes along with respecting the principle of non-refoulement, protecting people from being returned to environment of war or persecution, is the non-penalization for entry or presence. And that we can see in the South African legislation, in Zambian legislation, and legislation across the continent. Talking to statelessness for a moment. What is statelessness? Stateless individuals are not recognized as nationals or citizens of any country. Citizenship is considered it's the right to rights. We talk about belonging. I've put a link there, and I'm also happy to share it on the chat. But there's a big campaign called I Belong, run by UNHCR and partners, because without having a citizenship, without having nationality, it's like you don't exist. You don't have a right to rights. It is an untenable situation. And so in the efforts to end statelessness, there's a big push by the I Belong campaign of UNHCR. I also mentioned that it may have ramifications for further generations, because if a mother is stateless and she has a child, then that child, the statelessness often then passes from mother to child, and then you have intergenerational statelessness. Just a couple of examples in Madagascar and in Eswatini, both have legislation that allows only the one parent to pass nationality. So it's gender discriminatory. and this impacts and increases the chances of statelessness. A point I made just a little bit earlier, many states undertake to sign, but a lot of African states have not actually signed the statelessness conventions. An important thing to look up is your state or your country where you're working with Caritas or CPLO, is it party to the statelessness conventions? Has your country implemented any domestic legislation towards ending statelessness? There was also a joint statement in solidarity with statelessness, and that's a fairly recent thing. Just pushing because stateless people we'll find are often actually excluded or were excluded from protection in terms of the current COVID pandemic. And so there was this big call for solidarity with statelessness, an urgent call for states, donors, and other stakeholders to promote and protect the rights of stateless persons in their COVID-19 responses. So I thought I would just highlight that. All right, and then with human trafficking, with internally displaced persons, again, it's important to appraise ourselves of what it is. I mentioned briefly in terms of human trafficking, we're looking at an act, means, and purpose or exploitation. So you're looking at recruitment, transportation, transfer of people, and there's a threat or use of force or otherwise deception. And the purpose is that sort of profit motivation, that exploitation for profit in cash or kind. It's a very serious multinational issue, more lucrative than arms, illegal arms trade, and it is something that we need to have advocacy concerning. And then internally displaced persons. Father Rampe spoke to the Kampala Convention. 40 African countries are party to the convention, but there have been very few steps that have been taken to properly protect and safeguard the rights of internally displaced persons. Coming back to statelessness, in terms of the Abidjan Declaration, we can see highlighted there countries that are in the process of exceeding, as well as countries that have exceeded. They have signed and implemented the statelessness conventions. But it goes a step further in terms of domestication. So in terms of Article 24 of the Declaration, there was the push for developing of national action plans. And of the countries within the ECOWAS region, all countries except for Cape Verde, Niger, and Sierra Leone have adopted and developed, action plans to end statelessness. We also see a figure there: 45,000 persons who were stateless or at risk of statelessness have received identity documents since the declaration, including 34,000 birth certificates issued. So that's fantastic, and it's these kind of initiatives and this kind of implementation that we need to advocate for throughout the continent. Okay, I spoke to a little bit to the legislation in the Zambian context. In terms of the Ghana context, we see that Ghana is a party to the 51 Convention and the 69 Convention. Ghana is also a party to the Palermo Protocol, the protocol to prevent, suppress, and punish trafficking in persons, especially women and children, supplementing the United Nations Convention against transnational organized crime. And then Ghana has 3 main pieces of migration legislation: the Immigration Act, the Immigration Amendment Act, and immigration regulations. And that's provided for you there. Okay, I'm going to stop there. I could talk to refugee protection in South Africa. There's some rights that refugees have. One of the things that we see in the refugee advocacy space is that unfortunately some rights are being taken away. For example, that last line there, entitled to basic health services and primary education, that provision in the Refugees Act was taken away as of the beginning of this year. There are constitutional protections: the right to employment, right to education, right to healthcare. There are government directives in terms of accessing healthcare. There's also housing rights, right to safety and security. In South Africa, there's a provision also for a certain degree of social grants for recognized refugees, children's rights. Yeah, and that's everything. As I say, it is just a very sort of a broad overview, but asante sana, gratia, obrigado, thank you, tatenda chaijo. Thank you very much, everybody. And yeah, we're happy to take any questions that you may have.
Okay, thank you very much, James, and thank you, Rampe.
Please sign up for our newsletter at cplo.org.za.